Before I discuss a reward for creativity and the public interest, I would like to mention that although I'd like to think I've answered your questions with regard to fair use, candor forces me to admit that I haven't. If you have some questions, please ask me. Maybe I can stay here for a little while, and then also I've left some business cards, so you can email to me some questions, or else have a phone conversation. I'm on campus about 3 to 4 times each school year. We can have a discussion about any intellectual property issues you'd like to discuss. Also, if some of you intend to be in Los Angeles this summer and might be interested in an internship in a small intellectual property firm, I'd be glad to talk to you about it. Let's talk about reward for creativity and the public interest, and then possibly I can do some Q&A. The issue of reward for creativity and the public interest was debated about maybe 3 or 4 years ago in an interesting Supreme Court case involving copyrights. It didn't have to do with the fair use defense. It involved the Copyright Term Extension Act. There was a Copyright Term Extension Act, which was the legislation was effectively written by some legislators, Sonny Bono and a few others. Some people call it the Mickey Mouse Copyright Act. Every time the copyrights of Mickey Mouse are about ready to expire, Disney and some of its pals lobby the Congress to extend the copyright terms. And but the Copyright Term Extension Act went into effect, and in fact, under certain circumstances, it's possible for a copyright to have a term of almost 120 years. What's interesting about this case is that there was an interesting discussion on the record between Justice Ginsburg, speaking for the majority, and Justice Stevens and Breyer, speaking for the minority. Justice Stevens and Breyer characterized the reward to the individual as the secondary consideration. The only thing that we really have to consider is the public interest, or maybe just give the individual a certain amount of remuneration, but the public interest is paramount. Justice Ginsburg, however, took issue, and speaking for the majority, she said that they both have a substantial amount of importance, almost equal importance. Justice Ginsburg stated that Justice Stevens' characterization of reward to the author as a secondary consideration of copyright law understates the relationship between the rewards and the progress of science. As we have explained, the economic philosophy behind the copyright clause of the Constitution is the conviction that encouragement of individual effort by personal gain is the best way to advance public welfare through the talents of authors and inventors. Copyright law celebrates the profit motive, recognizing that the incentive to profit from the exploitation of copyrights will redound to the public benefit by resulting in the proliferation of knowledge. The profit motive is the engine that ensures the progress of science. I commend to you students of computer science, students of all sciences, students of the arts. Be as creative as you possibly can. Don't be shy about responding to the profit motive. Don't be defensive about responding to the profit motive, provided you make a commensurate contribution to the progress of science and the useful arts. Thank you for the opportunity to make this presentation. I hope it's been interesting and informative. Thank you. Yeah, I hope we have some time for Q&A. Is that in the time slot?
Just repeat the question so it gets picked up on the
Okay, I'll repeat the question. I'm going to have to ask you, if you would, please, to make the questions short, like put them in a few sound bites so that I can remember them. I'm not too good at remembering some of the questions. Sorry, anybody?
I'll take a crack.
Oh, yes, Dr. Leitner.
So given what you know about fair use, would you have been, and knowing that your lecture's going to be podcast out to the world, would you have been comfortable punctuating any of your remarks by showing a 5-minute video clip from a Viacom Hollywood production or something like that? In other words, would you have, in this lecture, would you have been comfortable showing 5 to 10 minutes of copyrighted work?
Yes. This is only for educational purposes. Oh, the question was, would I be comfortable to have used an uploaded 5-minute video clip of a Viacom copyrighted work, yes, well, this is all for educational purposes. I'm not doing this, well, I hope that my lecture is entertaining and interesting, but this is educational purposes. And I think that in this case, it's more like the type of situation where the student is using some copyrighted work just for educational purposes. I'm not doing that to do that, perhaps to take away from something I would otherwise pay a permission fee to Viacom for. Anyone have any questions?
Just one here.
Sir?
Yeah, what's the most interesting case you litigated? And that was, I guess, like, have the greatest impact on intellectual property.
Oh, actually, my practice is patents and trademarks and copyrights. So if I had to talk, the question was, what's the most interesting case that I've litigated? If I had to talk about a case that I was involved in that was the most interesting one, it would be the ENIAC patent infringement case. Shortly after law school, I was hired by one of two hired by Sperry Rand. I and another young lawyer were hired to give a trial lawyer backup on the litigation involving the patent infringement of the ENIAC patent. I had an opportunity to give a talk on the patent infringement litigation here about 2 or 3 months ago. And after 5 years of litigation, the court eventually invalidated the ENIAC patent. They sued, Sperry Rand sued Honeywell. Honeywell asserted an antitrust claim. And the court threw out the antitrust claim. And I think the moral of the story was there were some settlement negotiations. And if the parties had settled, they could have both won. It would have been a win-win situation. Instead, neither side won.
Tell them what ENIAC was.
The ENIAC was the first general-purpose programmable digital computer. It was built during the Second World War at the University of Pennsylvania. I know that the Mark IV was built here at Harvard. That was an electromechanical computer, very good computer. The ENIAC, though, was effectively the genesis of what some people refer to as the 20th century industrial revolution. That is the automation revolution.
One more.
Sorry, question?
You mentioned the relationship between Stanford and Google earlier. Is that distinction between like education, nonprofit, and for-profit industry do you envision it like changing in the future, or maybe going away or becoming more blurred than it already is, or is that something that you see staying the same?
Sorry, you say I mentioned Stanford and Google. Well, I should mention that a lot of the technology was based on research and development at Stanford. So Stanford receives a lot of revenue stream from the Google technology. And I think that the president of Stanford has a lot of stock in Google, and some of the professors, the computer science professors, there have a lot of stock in Google. You should have some stock in Google. I wish it on the CS professors, all of them at Harvard.